All right. Ownership of real estate. Ownership of real estate. Buyers must choose the best type of ownership that fits their needs. A lot of people are like, well, I thought owning real estate was just buying it and being on the deed. Nope. The choice of ownership can affect your future transferability or even have different tax implications. Real estate professionals can identify the basic forms of ownership in a state, but the buyer must explore the options and decide, preferably, obviously, with legal counsel. So you should have an attorney to help you with it. Okay. Now, real estate can be owned in three ways, governed by state law, of course. It could be in severalty, where there's only one owner. I'll explain severalty in a second. Okay. It could be co-ownership, where there's more than one owner. And it could be ownership by a trust. So property held for the benefit of another. All right. So let's start with ownership in severalty versus co-ownership. One person, corporation, or entity owns it in severalty. A sole owner is severed or cut off from other owners, hence the term severalty. An owner in severalty has sole ownership rights and can sell, lease, bequeath in a will, which we'll talk about, or otherwise transfer part or all of them. So you can transfer the rights. So pretty much what we're saying is that an ownership in severalty is one owner, whether it's an individual or a corporation. Okay, one owner. The reason why I'm saying like this is because a corporation could have 2 people, could have 10 people, could have 100 people, right? But because the name on the deed is one, that corporation is owned in severalty. When there's multiple owners, as we'll talk about later, when there's multiple owners of shares in a corporation, they own personal property called shares or stock. Okay? The company owns the real estate, hence in severalty. Okay, Nadia. Okay. Guys, cameras on, cameras on. Co-ownership. What is co-ownership? What is it? 2 or more people. Co-ownership, absolutely. Here's the co-ownership forms of ownership. We have what's called tenancy in common, or as I'll call it from now on, TIC. Tenancy in common means we're occupants or possessors in common. Okay? We hold something in common. That's what it is. So 2 or more people can own real estate as tenants in common, where each tenant has an undivided interest in the property. Each owner has unity of possession, meaning that they can use the whole property, even though they only own a fraction. For instance, I could put 25% into the property, and you put 75% into the property. That's 100% ownership, right? Okay, so I own 25, you own 75. How are we going to divide this house? I live in the basement and you take 2 floors? We don't. So our ownership is fractional. The usage is of the whole property. Okay? By right. By agreement is a different story, but by right, that's what it is. So it's the ownership, not the property, that is divided. Now, tenancy in common may or may not state each co-fractional owner's interest. So if no fractions or shares are stated, then the tenants are presumed to hold equal shares. So let's go back to the example. I put $25,000. You put $75,000. How are our shares divided? I put 25, you put $75,000. How are our shares divided? Come on, guys. Let me know in the chat. How are our shares or fractions or stock divided in the company? It sounds like that should be a simple answer, and you guys are giving me what the simple answer would be, but that could be incorrect. I'm getting people saying, hey, 25%, 75%. Nope. Let me tell you the answer. Thank you, Elizabeth. If there's nothing in the contract, let's change contract to deed, because this is not a contract. We own the property as individuals. So if the deed is your form of contract, okay, in this case. If the deed does not specify the ownership, shares, or fraction, then we own 50-50. Okay? I could put $1. You could put the rest of the for the 100,000. Okay? I could put $1 and still be 50% owned. If I don't specify on the deed, okay? If I don't specify on the deed, then it's presumed to be equal shares. Okay? This might be a question in the exam, so you got to know if we don't specify on the deed, it might be equal shares. So very important. If I put $1, Stephen McFadden says, not with me. All right, let's put it this way. I put $1, but I'll manage it forever. You don't have to worry about anything. My time, my knowledge, my experience is worth the amount of money you're putting in. The $1 is just a nominal fee. All right. So what I'm trying to say here is by agreement. A lot of my investments are that way, actually. In the beginning, I would put money. Now, more than ever, what I do is I put knowledge. So when I partner up with a lot of people, we become partners. I get like a percentage of it by knowledge, not by money. I have credit partners, I have money partners, and I am the expert partner. Let's put it like that. All right. So yeah, there's a chance that I didn't put any money. I put something equivalent to it. Okay. You want me to sell a bridge so you can jump off of? Somebody can jump off of it. All right. If 5 people hold the title, each one owns 1/5 interest. Co-owners can sell, mortgage, or transfer their TIC or tenancy in common interest without the other co-owners' consent, because we have fractional ownership. Okay. No tenant can transfer the ownership of the entire property, and I think that makes sense, right? If there's 3 of us, I cannot sell the house that we 3 own. I would need to have your permission to sell a house, right? I can only sell whatever is equivalent to my shares. If a co-owner dies, that tenant's undivided interest passes according to the decedent's will, if there is one, or by state statutes, if no will exists. Jefferson, great question, but in this ownership, it's not a voting right. This ownership gives us right to the whole property. So I cannot own more than 50% and say, oh, I'm the majority shareholder, so I'm selling the property. I cannot override those rights. Okay? I can sell my 51%. That's it. I cannot sell the whole thing. Okay? When 2 or more single people or couples acquire real property without indicating the form of ownership, they're usually considered tenants in common. So tenancy in common, it's automatic. If you don't specify any other type of ownership, make sure you don't have any phones, turn them around, please. This will become difficult if you guys are constantly having distractions. All right. The next one is joint tenancy or JT. Joint tenancy or JT. The right of survivorship is what distinguishes joint tenancy. What does this mean, right of survivorship? It simply means that if one of us dies, the other one acquires the shares. Okay? So a joint tenant's interest transfers to the surviving joint tenant or tenants upon the death. So basically, it's just one less person in the group of ownership. So if there's 3 of us, I'll do an illustration in a second. So if there's 3 of us, one of us dies, well, the shares are 50-50 now. It does not go to your heirs, it goes to the survivors of the group. Okay? No formal legal action is needed. or required as the descendant shares automatically pass to the surviving owners. This is another one of those that if you own property as joint tenants, you can put in the will, let's say it's three of us, so technically it's 1/3, right? I can put in the will that I'll leave 1/3 my shares to my heirs. But if we own it as a joint tenancy, the right of survivorship supersedes my will. So when I die, who does it go to? The survivors of the group. Okay, it does not go to my heirs. If there are only two joint tenants left, the death of one ends this type of tenancy. You see, the last survivor takes the title in severalty. The last survivor becomes the sole owner. If they're the sole owner, automatically becomes in severalty. Has sole ownership rights, including the rights to will the property to any heirs. Okay? All right, what if they both die together? Okay, clinically, that will never happen. That's how it is. So the way it works, I also teach life insurance and estate planning and all that stuff. So the way it works is very simple. If you get into a car crash with somebody else you own property together with, right? Or you have a life insurance together with, something like that. If you get into a car crash, start punching the person next to you. Let them die first so your heirs get the stuff. Okay? Because if you die first, their heirs get it. Okay? It's the time of death. By the time I'm just joking, but by the time the EMT gets there, they go one by one. Time of death. Okay, 12:01. Time of death, 12:02. Time of death, 12:03. So you guys never die exactly at the same time. Okay? That's how it is. So one last breath, punch. Okay? That's it. Too dark. I mean, it's 8:40. So this is day 2. It does not get any better than this. Okay, I'm just letting you know. It only goes down from here on. How do you create a joint tenancy? If you guys remember, I know it was a long time ago. It was like 2 minutes ago. If you guys remember, I said that tenants in commons like automatically, right? When 2 or more people own property, but they don't specify the type of ownership they want, usually tenants in common automatically, right? A joint tenancy is created by deed, will, or living trust, never by implication. That means it's not implied that we are joint tenants. We have to specify that that's how we want to become owners, right? So the instrument must state the party's intention to create a joint tenancy. It must state your intention to become joint tenants, okay? A joint tenancy requires 4 unities in order to be created, and that is possession, interest, time, title, or you can stutter. You can go there. All right. You got to have the unity of possession. For a joint tenancy to exist, all right, there's a unity of possession. What does that mean? It means that we hold an undivided right of possession to the property. We cannot divide. There's 3 of us. Oh, you get 1/3 possession. I get no. Or today you can use it, tomorrow. No, we have the right. Unity of interest. That means we have equal ownership interests. We cannot divide our shares again, right? Unity of time. That means our names go on that document on the same day. And what is that document called? Is the deed. So unity of title, we acquire our interest through the same document, the deed. Okay? These are 4 unities for joint tenancy to exist. If one of us shows up later, a different day, then we're not part of the same title, therefore we're not joint tenants. You got it? We have to be at the same closing table, signing the same document for it to be valid. Is that like singing a proprietary lease? We're not singing here. Not yet. I didn't have my Hennessy yet, so no. Proprietary lease is for co-ops. It's a little different. We'll talk about it later. Let's see. I got 1, 2, 3, 4, 5 cameras that I cannot see properly. So make sure your cameras are on. You have enough light, and I can see you. It's tough, right? Here I can throw something at you if you're not paying attention. At home, I can't. Believe it or not, I used to have a teacher, French teacher, back in Catholic school. Imagine that. If we're not paying attention, he was writing on the board, right? This guy had the best aim ever. I think he had eyes in the back of his head because he would just do this motion, boom, right at the person that he needed to hit. Unbelievable aim. Oh, I don't know. And it was French. I'm like, don't be so serious about it. Nobody's going to speak that language in a few years anyway. Sorry if you speak French. I'm sorry. Or if you're French. All right. So 4 requirements or unities are met when all joint owners acquire the right of possession of a property through a single instrument that simultaneously conveys an equal undivided interest and stipulates that this property is thus owned jointly with the right of survivorship. So everybody acquires the same right of survivorship. How do you terminate a joint tenancy? Easy. Either by everybody dying and becomes a sole proprietor, right? So a tenancy in severalty, right? So you can choose what to do with your partners. Very easy, right? Or by selling your interest. The moment you sell your interest, if one of the unit ends, the moment you sell your interest, so does the joint tenancy on that particular share. Okay. So unless state law prohibits it, joint tenants are free to transfer or sell their interest or give their interest in the jointly held property. Although doing so destroys the unity of time and title. I'll give you an example. I will illustrate in a second. If I said, let's say we buy the property together. All right. So Randy and Joshua and Nadia and I, so 4 of us, we buy the property together. Okay. Same day, today, at the same time, right? We buy the property together. Then I said, you know what? I don't want to deal with these people, right? They're great, but I don't want to deal with them. I want to sell my shares to somebody else, right? Especially because I think Nadia is out to kill me. I don't know. That's a feeling I got, right? So I want to get rid of this before something happens. So I'm going to find, let's say, Jefferson. I'm going to find Jefferson and say, hey, Jefferson, I have this building that I purchased with 3 other people, and I'm selling my interest. So 25% ownership in the building. And Jefferson says, sure, I want to be part of it. Now, because Jefferson came days later, is he part of the joint tenancy? No. Nadia, Joshua, and Randy are still part of the joint tenancy, while Jefferson is a tenant in common. Jefferson, whoever comes later, can never own the right of a joint tenancy. That's something you must remember. Whoever comes later can never own the rights of joint tenancy. Okay? Very, very important. So they become a tenant in common, not a joint tenant. We good so far? Okay. Cool. All right. Termination of co-ownership by partition suit. So when you hear the word partition, it's not about Beyonce's song. We're talking about separating the title to the property. Okay. Separating. This could be either a physical partition or a judicial partition. But partition means ending or separating. Okay. It's a legal way to end a co-ownership relationship when the parties don't agree. All right. So we like the property, but one of us wants to sell the property. Why would I want to sell the property? Because maybe I cannot sell the shares. Maybe Jefferson didn't want to buy it from me. And I went around and I went to Zavdi didn't want to buy, Elvis didn't want to buy, Samaya didn't want to buy. I'm like, oh, nobody wants to buy my shares. How do I get rid of it? Okay. It's either by physical partition or by judicial partition. What does that mean? We either can physically separate it. Let's say it's a lot that we can divide it, right? Or if we cannot divide it, the court will say, hey, you know what? Since you guys don't come into an agreement and there's no way to physically separate it, I'm going to order this sold, and then you share, you receive the shares, your fraction of the profits. So if I'm a 25% owner, what would I get? 25% of the profits. Does that make sense? So physical is if we can physically divide. Judicial is a court-ordered sale, and then the proceeds are divided according to the shares. All right. Next one is married couples ownership. This is called tenancy by the entirety. Here in New Jersey. In other states, it could be different. But tenancy by the entirety is specific to married couples, unless they choose tenancy in common. But automatically, tenancy by the entirety is what we call when it's a married couple. Now, in states where tenancy by entirety is recognized, a surviving spouse is allowed to inherit the other's ownership interest upon death. Each spouse has an equal and undivided interest in the property, and the term entirety means that they are as one legal person. The same thing with joint tenants. These are very similar. Joint tenants, the four of us, were one legal person, or at least acting as if one legal person. Okay, joint tenants. So they are considered to be one indivisible unit, and during their lives, only a deed signed by both parties can transfer the title. One party can't transfer a half interest and can't divide the property, as there is no right to partition. That's one of the differences in the marriage. In the marriage, you cannot sue the other party to separate the assets. That lawsuit is actually called divorce. It's the only type of lawsuit between married that can happen between married people. Nadia is asking, so if I'm the sole owner of a home and die, he gets the home unless on no. So this was talking about we both own it, married couple. So we both own the property and we married. So both names are there and we married. That's what I was talking about here. Okay. If you're the sole owner, then you have to figure out if the property is in a state where dower and courtesy still exists, then yes, he would still get it. If it's in a state where dower and courtesy no longer exists, like New Jersey, then most likely not. Your heirs would get it. Okay, if you're the sole owner. Hashtag prenup. God. All right, guys. Bathroom breaks should happen before. I'm okay with you guys going for bathroom, but everybody's going like before starting the class, unless you have a medical problem. Before starting class, during the break, or right after. All right, that's the only thing I'm asking, because then you're losing valuable time and information. Oh, Elvis is not sleeping. He's awake. Right, Elvis? There you go. He opened his eye. Elvis is back in the building, ladies and gentlemen. All right. Guys, you can go through this table for study. Tenancy and severalty, tenancy in common, joint tenancy, tenancy by the entirety. It's just a quick summary of definition, creation, possession, title, conveyance, and effect of death. The creditor's rights, if the creditor is somebody that you owe money to, and presumption, okay? Next, we have trusts and business organizations. So as you guys know, we can own property as a business, right? So until now, we were talking about as an individual, as two or more individuals not married, or individuals, two people married, right? All right. So those of you that have medical conditions or pregnancy, which is a medical condition, you have the excuse to go to the bathroom more than once. That's okay. All right. Everybody else, you're fired if you keep on going to the bathroom. All right. I took a break and I didn't go to the bathroom because two people are occupying the bathroom, and I'm here holding it, okay? For you. I'm holding it for you. So hold it for yourself too. Somebody's going to be like, but my doctor said it's bad to hold. I'm like, I know it is. That's why you go before the break and later. Thank you, Masha. I think I am. She's like, what a nice guy. The sacrifices I do for you guys. All right. So trusts in business organizations. Like I said, you can own it as a hero behavior. There you go. You can own it as a business, and that brings you additional protection, both as a business or as a trust. A trust transfers the property ownership to another person to manage for a third party. For instance, a parent may want to pay for a child's college, right? The parent can transfer enough money to cover the child's tuition and expenses to a bank account with a trustee, okay? The trustee can be instructed to use the account funds for college tuition only. The parent, in this case, is the trustor and the person that creates the trust. The child is a trust beneficiary, and the trustee owns the legal title to the property and carries out the trustor's instructions. We'll relate this to real estate in a second. The trustee acts as a fiduciary. We'll go over this word several times. This is a person with a special legal relationship with the beneficiary and acts in trust and confidence on their behalf. The trust agreement establishes the limits and the trustee's authority. So almost like a power of attorney. Well, you give them certain powers over the trust and the benefits of the trust and the assets of the trust. Okay. Now, most states also allow the property to be held in a trust. The trustor, trustee, and beneficiary can either be individuals, legal entities such as corporations, depending on the type of trust and its purpose. Real quick, we have living and testamentary trusts. By creating these trusts, property owners can provide financial care for themselves and their families, and the trust can be created during the owner's lifetime. It's called a living trust, or by will after death. It's called a testamentary trust. The person who creates the trust transfers the real or personal property to a trustee, usually a corporation, who assumes certain duties. These responsibilities may include investing trust assets to generate income. And after operating expenses and trustee fees, the income goes to the beneficiary. So make it a power of attorney mixed with property management. That's your trustee. They will act on your behalf. They'll try to raise enough money from the property, pay off the expenses, pay off themselves the fees, and whatever's left over goes to the beneficiary of the trust, which could be somebody that I appoint, right? Or it could be myself. The trust may last the beneficiary's lifetime, distribute the assets when they reach a certain age, or other conditions. A living trust transfers real and personal property from a trustor to the trustee, and the trustor is often named the trustee. So the owner controls the trust's assets. This is just a way, like a corporation, is just a way to pass on liability to somewhere else. So free yourself from individual liability. So protect your assets, right? So this way, the trustee's estate passes to the beneficiary. Subject to the trust agreement, the trustee can transfer the property into and out of the trusts. Why would we do this? One way is to avoid probate. Probate is something that happens when you die, which is going to court and having to figure out who the heirs are and people that claim. We're going to talk about it later as well. Heirs, claimants, death claimants, and all that. So if it's under the trust, then nobody sees that person died. Do you understand? Nobody sees that person die because the property is owned, just like a corporation's owned by the corporation, not the individual. So if somebody dies, we just, hey, replace, new person. It's like a shield, a protection. Okay. So the estate distributed to the beneficiaries upon the death of the surviving trustee. If it's a land trust, it's specific for real estate, so therefore only owns real property. All right. I'm going to skip this for now because I just very much addressed it. I'm going to go straight to owning it as a business. It could be a sole proprietor, it could be a partnership, right? It could be a corporation, it could be an LLC, and so on. So going real quick here to partnerships. It's a form of ownership. So two or more people can own a business in a partnership. If it's a general partnership, all owners are general partners, so they all operate and manage the business and share full liability for business losses and obligations. This is what you got to know. If it's a general partnership, okay, you share full liability for business losses and obligations. For the state exam, that's what you got to know. Okay, partnerships. If it's a limited partnership, then we have at least one general partner and as well as limited partners. The general partner runs the business while the limited partner is traditionally considered a silent partner. And as such, limited partners' financial exposure, that's the other thing you got to remember, financial exposure to business losses is capped at the amount of their initial investment. So technically, limited partnerships allows small investors to participate in large real estate projects with minimal risk. Okay, it's a very popular way to get people into real estate. Say, hey, it's a partnership. I handle everything. You're just an investor. I'll give you a return on your money. So let's say I get $10,000 from everybody here. If we make money, we all happy. If we lose money, you're not going to be sad. You're not going to be happy, but you're not going to be that sad. Because if we get sued for $1 million, you lose 10, I have to pay the difference. Does that make sense? So limited partners, they're capped at their initial investment. Okay. Real quick, I don't want you to do this for state exam purposes, but for real life purposes, never do a partnership, please. Ever, 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 ever. Okay. It's either a corporation or an LLC. I'm going to explain, Ashley. I'm getting there. Masha's asking, what's the difference between co-ownership and partnership? Let's go back to co-ownership. There's either inseverability, where you're one, or co-ownership is two or more, right? We can have two partnerships own property. Okay, that's a co-ownership. If it's one partnership owning property, then that's inseverability. Okay, so let's say, Ashley, you and I are partners, and then let's see, Yolanda and Masha, they're two partners as well. Partnership A and partnership B buy property together. They're co-owners. If it's only partnership A, then they're sole proprietors. Does that make sense? Yep. What was that? It depends on who's on title. So let's say my partnership A, right, is the owner of the deed, like it's the name on the deed. Then there's only one entity listed on the deed. There's two people to that entity, but what lists on the deed, on the title, is one. That's why it makes it a tenancy inseverability. But if it says partnership A and partnership B own this property, then it's a co-ownership. What's behind the scenes doesn't matter. It could be two partners, it could be 10 partners, it could be 1,000 partners on this end. But what shows on the deed is what matters. If it's one partnership or one corporation or one LLC, then it's a tenancy inseverability. You got it? Okay. So Ashley was asking, why never do a partnership? Okay. Because there's no protection. As a general partner, you have full liability for the business, and it extends beyond the business. Okay? It extends beyond the business. That liability, look, let's say we own property together, you and I, Ashley. You have $1 million in the bank, I got $100 in the bank. Okay? If we get sued for $1 million in the business, it could extend to your personal assets. Which one of us can afford to pay this? I only have $100. All right. Maybe you want to sell my car. It'll be another 15 grand. I think it's what it's worth now. Right. But Ashley, I'm sorry, you're stuck with the bill. That's the problem with partnerships. What you want to have is a corporation or an LLC, or even, as we mentioned before, a trust, where it kind of like separates what your personal is from the business. Okay. The advantage of corporations and LLCs is pretty much a shield, a liability shield between the business and yourself. Elizabeth is asking, if I decide to open up an LLC to change the deeds to the LLC instead of my name. Here's the thing about that. If you have a mortgage, you got to talk to the bank. You have to let the lender know that what you're trying to do is change the deed to somebody else. We'll talk about that in the financing chapter. I think chapter 14, because the banks usually have a clause in the mortgage that says if you change ownership, we want the whole money. Okay, so if you owe $300,000, they want the whole $300,000 now, because the loan is against you, right, or with your guarantee, not with somebody else. Okay, so you have to explain to them, hey guys, Bank of America, I'm trying to change the deeds to my LLC. Is that okay with you guys? They give you the okay, you change. They just want you to sign an agreement that you're still personally liable for it. That's all. Okay? So always talk to your, well, you still owe the full amount, Ashley, as an individual. The advantage of the LLC is that when somebody searches for who's the owner, they will see the LLC, not you. Okay? So if somebody slips and falls, they'll sue the LLC, not you. The money you owe the bank, you still got to pay it. You're still personally liable. Unless you purchased it, unless you got a loan under the LLC. All right? But guys, we'll address that better when we get to that chapter. Let's move forward here. Correct. Owing what is still left. Yep. All right. So corporation is considered, so these right here. I'm going to write shield. Okay. So corporation is a legal entity considered an artificial person created under the authority of the state law. A corporation's board of directors is chosen by its shareholders. The board of directors chooses the officers who run the company day to day. The corporate charter includes the liability to buy and sell real estate based on a resolution by the board of directors. A corporation can own real estate privately or as a tenant in common, with others as a legal entity. A corporation exists as a legal entity until it's dissolved, and the death of an officer or director doesn't affect the corporate property. So like I said before, there's no probate if it's under a corporation, right? Because what you own is shares, not the real estate. Who owns the real estate if it's a corporation? You own shares. Who owns the real estate? Who owns the property? The corporation does, absolutely. All right? Corporation owns the property, you own shares to the corporation. So when you die, it doesn't go through probate. The corporation still owns the property. Okay? Then my favorite, LLCs. An LLC is like a mix between the corporation and partnership. So it gives you flexibility, tax advantages that a corporation does not. Okay. It's a relatively new business organization in the United States, very common in Europe. An LLC combines limited partnerships and corporations. LLC members enjoy the corporate style limited liability mixed with the tax advantages of a partnership, with income flowing directly to the members instead of being taxed twice by a corporation. That's one of the disadvantages of corps. You get taxed as a corporation and then on your shares as an individual. Okay. The LLC has a flexible management structure, unlike a corporation or limited partnership. And of course, state-by-state structures and methods for forming a new LLC or converting one to an existing one vary. So from state to state. I have a Zoom user. Make sure you change your name, please. All right. Next, we have condominiums, co-ops, and timeshares. So condominiums. I'll go straight to the figure here. Condominiums, to make it simple. Here's what you own in the condominium. Ready? You own this space right here, air. That's it. Whatever's inside the walls. Other owners own the 2, 3, 4, 5, 6, 7, and so on. The advantage of a condominium is that you get to share recreational facilities. For instance, a pool, a gym, you have your own private parking. These are your common elements. So what do you get with a condo? You get the title and the deeds to the unit, and then you have governance, conditions, and restrictions to the common elements. So even though you own the pool, right? You own the pool, you cannot destroy the pool. Does that make sense? All right. So that's condo. Have you heard of co-ops? Cooperative ownership? It's very similar to condo, right? It's the same image. Very similar. What is the difference? Can you tell me what's the difference here between the previous image and this one? What is the difference? It's one word. Leased, not owned. Okay? So it's still the same. You still get to share common elements. It's like apartment living. You get to share common elements. You have the pool, you have the gym, whatever's available. The amenities are available. But instead of owning your space, you lease your space. Okay? So what do we own in a co-op? Why not just be a tenant? The thing is, you own stock. So in the previous image, we had a deed over here. Now we have stock. Stock that gives you the right. So 1/12 of all, because there's 12 units here. So we equally own. So the shares are divided equally. 1/12. So there's 12 units, 1/12. Certificate to the company. So the co-op ownership, you own stock. So therefore, company. The company owns the whole structure. Okay. What you get is called a proprietary lease that allows you to occupy this unit right here. Right. You get a proprietary lease. So to make it simple, let's go back up. If it's a condo, you get a deed entitled to your units and common elements, right? If you have a co-op, you are a tenant because you have a lease, but you are a tenant that owns part of the corporation that owns the whole thing. Does that make sense? Okay. All right. The biggest difference between these two, besides that, is how the fees are delegated. Okay. So obviously, if you own a unit, then you are taxed individually in that unit. Okay. If you own a unit, you're taxed individually. You also have your individual insurance. You have your individual mortgage. Everything is individual when it comes to a condo, just like a single family. Okay? Condo operates very similar to single family. Okay? Where co-op, very similar to apartments, apartment living, if the tenants stop paying the rent, half of the tenants stop paying the rent, right? Then what happens to the building? The whole building is foreclosed. You don't have an individual tax bill. You don't have an individual insurance. You don't have an individual mortgage. In a co-op, we all contribute to the corporation, and then the corporation pays all the bills. If the tenant shareholders do not pay for those bills, then the landlord, which is a corporation, is forced to foreclosure. Okay? Any questions here? No? Elvis just came to life and says, nah. I don't know what that means. Nah, you don't want it, or nah, you don't have questions, or what kind of nah did I get? Masha, so what do you end up with if the building foreclosed due to other people's inability to pay? What do you think? In a condo, your neighbor's foreclosure does not affect you. You still have the property. In a co-op, if the building is foreclosed, what happens to your interest, to your benefits, to your shares? Coney goes like homeless. Yep, gone. That's why usually when you're in a co-op, they check your income. So just like being a tenant, they do a background check. They check how much income you have. They verify everything. It's not just the bank doing it. The corporation or the board of directors do it as well to make sure that you're not at risk of defaulting. Okay. So yeah, very high risk. Nadia, if you sell the co-op, what type of ROI can you or would you get? Depends. I mean, if the building goes up in value, the whole building goes up in value, so does your stock. So the return on investment is based on the stock, just like anything else, right? It could vary. If there's a demand for co-ops, value goes up. You sell your stock for higher. You got it? It's tough for me to give you a percentage. It's like you're asking me on the regular property, single family home, what's the ROI you can get? I don't know, depending on the market you're investing in, depending on how much money you're putting in, what the deal was like. I don't know. Okay. All right. I got a bunch of cameras off and a bunch of people not on camera. These are the delays we get. I don't see your faces. It does not count. And if you guys think I'm playing, you know that yesterday I kicked somebody out. So, okay. It's for you, not for me. I'm here. My face is here in this little square here. You see it? My face, half of my body almost, right? My arms wiggling, right? So if I'm here, you have to be here. Next time, what I'll do is I'll record these and just let it play. Then I can also go do other stuff while in class, right? Anyway. All right, last one, so I can send you guys home. I mean, let you guys go. Timeshare. Who knows what a timeshare is? Who knows what a timeshare is? Oh, by the way, I skipped some stuff because we either talked as an example or we have addressed before, or I'll address it later. You still have to read though. That's part of your homework, okay? What is a timeshare? Who knows what a timeshare is? Shakir says a scam. Steven says a really good scam. A lot of people, and I've said this before, call it time scams. Yes. But you know what? I'll put it this way. Everything in life is a scam. Everything. But also everything in life is good. It just depends on what benefits are you looking for. A relationship could be a scam. A job could be a scam. Education could be a scam. It just depends on what you're looking for. A lot of people call Herbalife a scam, but hey, a lot of people make a ton of money in Herbalife. A lot of people call sports a scam, but people bet every day and they make a ton of money. Okay. So timeshares are good for somebody like my business partner. Every year, 2 or 3 times a year, he goes and takes advantage of that week. Like whatever timeshares he has, he goes and just has fun. Okay. But for most people that own timeshares, it's bad because they don't get to use it. That's why we feel like it's a scam. Partially, that's why we feel it's a scam. Anyway, but a timeshare is, yes, a vacation rental. Could be. It could be a timeshare. It could be a shared workspace as well. It's a timeshare. There's different variations of timeshares. But it is for a limited time, therefore called timeshare. Your time into that particular property is limited. So multiple buyers can buy small timeshare interests in resort properties, as an example. Each buyer receives a time-limited tenancy or occupancy, as you know. A timeshare estate is a real property interest in a specified unit for a specified period of the year, or a fractional interest or number of points in the property. The developer owns the property under the timeshare use contract, and the timeshare owner can use the facilities for a limited time each year, and the owner's rights expire right after that time. A timeshare ownership can be attractive because of the ability to transfer or exchange the use between the properties in the same organization. So what a lot of people get into timeshares is because usually the corporation owns a lot of different spots, vacation resorts around the United States or around the world, right? So you get into a timeshare and you have the ability to go to any of these sometimes, right? High development and marketing costs make timeshares an expensive form of property ownership, as evidenced by the discounts on the real sale sites. If you ever try to sell your timeshares, there's a lot of discounts. It's easy to buy, hard to sell. Okay. Even if the timeshare isn't used, another thing to remember is that maintenance costs continue. So you have 1 week timeshare, but you have year-round maintenance and taxes. That's one of the things they don't tell you at the sale, and that's why you feel scammed. Membership camping is like a timeshare. The owner buys the developer's facilities, usually an open area, with minimal improvements, such as a camper or trailer hookups and restrooms. Complex state laws regulate development and sale of timeshare units.